Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors legal hotline lawyer. This is another episode in our series entitled, You Mean I Actually Have to Read the Title Commitment? In this video series, we are fortunate to be joined by Jake Mensinger. Would you introduce yourself just a bit?
Sure. Jake Mensinger here, title officer down in Vancouver, Washington with First American Title. So happy to be here and chatting with you a bit.
Thank you. And I'm going to lean heavily on you for this particular episode. In this episode, we're talking about the broad category of insurable ingress egress, or the lack of insurable ingress egress is how you're more likely to see it on a title commitment. I'm going to tell you that many of you are going to go through your entire career without ever confronting an issue about insurable ingress or egress on the title commitment. If you're selling property on a city block or in a platted subdivision type community, you are likely to not see anything on your preliminary commitment for title regarding ingress egress. So Jake, when will brokers see something about ingress egress on a title report?
Sure. Typically, how you're going to see it is in your legal description. Typically, is going to be your access easement. If you have an easement, it may be a parcel 2, a parcel 1A, something like that. But it's going to be spelled out there, usually within your legal description. If you're in like you had mentioned, like a subdivision, and you're on a public road, or maybe that easement was created in the plat, we don't necessarily call it out. We just say lot 42 of whatever subdivision. But typically you're going to see it on that legal description. And then if there's a problem, you're going to see called out exception in the title report in your Schedule B, Part 2, that says some sort of lack of insurable access. And that means is we're not abutting a public road, or we don't have any sort of easement that gets us to a public road of record.
Okay, so that is the problem, is that the property has to be accessible to a public road.
Correct. You got to get there, right? Most people aren't just walking to their homes these days.
Flying?
Yeah, or flying.
Jetsons, we're not in the Jetsons era yet.
Yeah.
And so the question, brokers, is what can the title company learn from the public records about how the property that is here is going to get to the county road that's over here, right? That's the question to be solved. And so, Jake, what happens if there is no easement recorded for access?
Sure. I don't think we're going to close. Most of the time, someone's going to want that access, and I don't know. I can't think of a situation. Maybe if they owned the adjacent lot, the buyer did, but I can't think of a situation where a buyer is going to want to take a title subject to a lack of access.
Yeah.
So you're going to be talking to neighbors and figuring out, where do I get that access? Do I need to get a new easement, obviously, from these new neighbors? And do I need to hire a surveyor to come up with a legal description for this easement? Then I'm going to have to hire an attorney or someone to draft up this easement document. So it's not, easement is not really something an escrow or title is going to be able to create for you. Our escrow officers aren't licensed to prepare them. So unfortunately, a lot of times it's just, you got to have an attorney prepare those for you. So.
And or a surveyor might require both. Certainly, it's not something that a real estate broker is licensed to prepare. So brokers, what Jake is describing is landlocked property. And there are solutions for landlocked property. Almost none of the solutions are quick. If you've got, as Jake suggested, if you've got a neighbor who will grant an easement, that even if the neighbor agrees quickly to grant an easement, it's probably not going to be a quick process, because there is going to have to be a survey done to identify the legal description of the easement, and then the easement document itself prepared and signed and recorded, which can be very fast, but the survey is typically not. But usually, if you're dealing with landlocked property, there's a reason it's landlocked. And so the solution is not necessarily going to be simple. There's probably not a neighbor who just says, oh, sure, I'll grant you an easement across my property. It may require a lawsuit by the landlocked party in order to have a court essentially force surrounding neighbors to grant an access easement. And then there can be restrictions on the type of access that come with that court-imposed access easement. So really, if you see on a title report that there is no insurable access, listing brokers, stop what you're doing. Go talk to your designated broker. It's more than likely that the seller is going to have to resolve this problem before you proceed with the listing. It is possible to sell property that is landlocked. Somebody had sold to the seller who's selling now, right? Or that landlocked parcel could have been created to be a landlocked parcel through the division of other property that got sold off without an access easement being reserved to this property. But in some fashion, this property owner became the owner of this landlocked property. So it's not that it's impossible to sell it, but as Jake mentioned, that buyer is going to take the property in its landlocked condition without an access easement to it. So how then is that problem going to get solved? Whether you're working with the seller or the buyer, that is not a problem that you can solve. It's not a problem that the title officer can solve. That is a problem that you must advise your client to talk to a lawyer for resolution. It's really just that simple.
Yeah. A couple of the other things that I kind of see kind of come up with those easements for ingress, egress. Maybe the easement has started off over the west 30 feet. Throughout the years, the road has kind of meandered outside of that 30 feet. I may make an exception to that on my title report. If I look at the aerial and I see that road is maybe gone over across someone's property that we didn't have an easement to and then kind of comes back to us. So those are kind of situations where, again, throughout the years, the road changes and you may see an issue there where you have an access easement, but it's actually changed or not the access you're using.
Yeah.
Sort of a thing.
Yeah. So then the question is, will that be a problem? Who knows, right? Will that be a problem for closing? Will that be a problem for this buyer's ongoing ownership and use of the property in that driveway? Who knows? It's the kind of thing, though, that once it gets called out as an exception on the title report, the title company is now out of the mix if there is a problem in the future. And so your buyer needs to be advised to seek legal counsel with respect to the fact that the insured easement access is not where the driveway is located. Maybe buyer will never have a problem with that, but it's your job, broker, to make sure that that buyer is advised to seek the advice of an expert in that area. So if it's a surveyor or a lawyer or a title officer, and maybe the title officer says, I can't answer that question, they need to go talk to a lawyer. Brokers, make sure that you are calling out to your client the fact that there is this exception on title, which is unusual, and they ought to talk to an expert before they move forward in the transaction. And as is always the case, put any advice like that in writing so that it can be provably delivered, and later there can be no question that you delivered that advice to seek the expert opinion. What about road maintenance agreements?
Sure. Yeah, we see those. Here's the other thing about easements that I will mention too is like when I'm doing my exam, I'm searching this property that you own, but I'm also kind of doing an exam on that easement. So I'm making sure at least somewhere along the line that all the people that sign that easement, sign the easement. All the owners that own the property the easement is going through have signed it. So a lot of times you may see that maybe there's only 3 people, they create the easement, and they just didn't ever think to record a road maintenance agreement or do anything. We've seen that. A lot of the times the lenders want to see a road maintenance agreement. They don't just want to hear, well, the state of Washington says that anyone that uses the road, it kind of has some obligation to maintain a private road and kind of that route. So we have seen where lenders will say, we want to see a road maintenance agreement recorded before we'll insure this transaction. And then you got to go around to each person and get that, signature and everything. The other kind of question about it too is if you're getting a new easement from somebody, not only do you get the easement from them, you get the survey, you get maybe an attorney to draft it. What if they have a loan on their property?
Oh, yeah.
You have to get their lender to acknowledge this new easement. So I have a concern from a title company if you don't, because if that lender forecloses, that wasn't on their title report when they took out the loan. And so do they have to honor that easement? That could be a concern of ours. So
yeah, the foreclosure could wipe out the easement is what Jake is saying. And so if he's insured access to the property at the end of the road without the lender's signature by the person who owns the property before you get to the end of the property, and that lender ends up foreclosing the debt on that property, that would eliminate the easement that the property owner had granted. So what Jake is talking about here is private roads only. If you're on a county road, city road, you're not going to have a road maintenance agreement. Don't worry if you don't see one. If you're in a subdivision, it probably has CC&Rs that put the burden of maintaining that road on already on parties, often the association or maybe the individuals who confront the road. It's already covered though in the CC&Rs. What the scenario that comes up most often in closing transactions is anytime property is located on a private road. And oftentimes these are older homes. People have lived in down these long private roads for years and years and years. It's never been an issue. Somebody comes out there once every year or 2 years and fills the potholes, and nobody ever really even talks about it, and they just get along as neighbors. That doesn't work for a lot of lenders, as Jake identified. And so there has to be an agreement specifying who is going to be responsible and in what proration and et cetera, for the length of the road. And let me assure you, if you've never been through this process before where you learn 10 days prior to closing that there has to be a road maintenance agreement and you've got to collect 8 signatures on this road maintenance agreement, it is not an easy process. And you are unlikely to close the transaction, or at least close it timely. So again, this is another one of those issues that is a perfect example. If this is an issue on your preliminary commitment, and the good news is it's not going to be for most of you, but if this is an issue on your preliminary commitment for title, the sooner you start to grapple with this issue, the greater the likelihood you will be paid in this transaction.
So I guess a good indicator to me, kind of just for brokers, if you've got your legal description has a Ingress Egress sort of easement in it, look at your title report. Is there a road maintenance agreement? And then if there's not, and you're working with a lender, maybe talk to that lender have the buyer's agent talk to their lender, make sure that that's not going to be a hiccup or anything. Maybe ask the title officer to do a second double check to make sure they're not missing any sort of road maintenance agreement. What happens a lot of times is they'll put road maintenance provisions maybe on a deed, maybe on that first deed that was created. And so if I can find that, and maybe we missed it originally, then I could show the lender that there's something that maybe they're fine, right?
Yeah. Or in the original easement agreement, it might just be labeled easement agreement, but it might include some road maintenance requirements that are enough.
Yeah, and on the recorded plats, usually they'll have a little blurb if you're on a private road within a plat. Maybe it's, certain roads are private, certain roads are public, but it'll usually say a little provision about road maintenance is responsibility of the owners using the road or something like that.
If you have questions on this topic or any other, ask me a question by visiting warealtor.org and following the links to the legal hotline. Thank you for being a Washington Realtors member.